really the issue I want to focus on before we get to those issues is why we need a continuance, which is to say we're all here. I've done 3 or 4 cases already this morning. We're here. I'm here. We're all here. The facts are here. I've read through 300 pages worth of stuff to get ready for the hearing. Why why is there a need for a continuance?
Because I'm not prepared, and I would like to obtain a lawyer. I'm not prepared for this. I was just notified on the 10th.
Is
I've
there
been.
any other reason, which is then that you're not?
I was going to file a countersuit against her, but you guys didn't receive my documents. So other than that, no.
Mr. Osborne, if you'd like to be heard in regard to the continuance threshold issue.
Your Honor, we are here. We are ready to proceed with this. We have provided, I will say I'm a little confused on this idea. She wants to do a countersuit because technically that would have been served on me, as we've seen even with a mistake of something like her response and continuance, which was not signed but was served upon me. Even that, as an officer of court, I have put into the record. We put our response. We treated everything as professionally and diligently as we can in this matter. So if she was going to do that, we would have been served on that. In checking this morning, I have no emails to that effect.
Your Honor.
You'll have an opportunity to wait.
So I would ask that that be considered for what it's worth, that if I don't have a copy and I've been diligent enough to respond within a day of receiving the previous, we would have adequately responded in this matter. So we'd ask the court to deny that so we can proceed forward today.
Ms. Chappell or Mr. McKenzie, anything else in regard to your motion to continue today's hearing?
Yes, I sent Mr. Osborne the counterclaim, and I have an email proving I did. He responded to me about it.
Oh, yes. That.
What she's or the Freedom of Information Act stuff?
No, she is responding to what I believe to be a motion that she filed in the Sixth Circuit Court of Appeals. I have responded to that in the plaintiff's response because with that there was a question on that because the Sixth Circuit of Appeals does not have the ability to grant an injunction, and so that was obviously taking care of that.
No.
And so that would be null and void at this point. I've actually talked to the attorney representing Children's Services in that matter, and even they admit that Metropolitan Housing has not been named as a party correctly, and so in that way they do not believe we have to respond to the Sixth Circuit. And so we've documented everything as part of the 370 pages so that everything could proceed and the court could see what's going on with that file.
Okay, thank you. I think I'm prepared to rule on a couple of threshold issues. Again, this court is going to construe what I'm referring to as Plaintiff's Exhibit A. Now, this would be the Exhibit A in the black binder notebook that was actually filed by the plaintiff. The court is going to liberally construe that response as an answer with a motion to continue is the defendant's motion. That threshold question is going to be ruled upon by the court at this time following opportunity for the parties to be heard. The defendant, McKenzie and Chappell, their motion to continue today's hearing will be denied and overruled, which puts us in the situation of today we're going to have a hearing on who has the right to the possession